In this part of the lecture, we look at other issues related to choice of forum, selecting the place where the dispute will be heard. Now, we've already talked about jurisdiction, and we've talked about how it's the most important concept. There are other concepts that might be at play as well. And the first is a concept called venue. And again, this is a word you've probably heard in some context. And in the legal context, when we talk about venue, we talk about this is the proper geographical location to have the dispute resolved. Now, venue is often confused with jurisdiction because essentially we have a court that has jurisdiction, but that court must also have venue. It must be the best place to hear the dispute. And so venue often comes up when there are two courts that each can assert jurisdiction over the case. When we have that situation comes up, venue would indicate which court should actually hear the case. Which is the proper geographic location to hear the dispute. When we talk about venue, you should also be aware that unlike jurisdiction, which is a threshold question, a party can agree to a venue in an area that may not be the proper geographical location. A party cannot waive jurisdiction. We cannot simply agree among ourselves that this particular court can hear the type of dispute or exercise authority over the parties to the dispute. However, we can agree among ourselves that this court is a proper geographic location to hear the lawsuit. Again, we're not going to talk a lot about venue because it's a complicated topic, but in essence, what I want you to take away from this is that venue refers to the proper geographical location. Venue can be waived, venue can be agreed upon. It is not the all or nothing that jurisdiction is. Now, another topic, another concept that comes up in terms of forum selection is called forum nonconvenience. And forum nonconvenience is a common law legal doctrine. I mean, it's a legal doctrine that is used in common law countries like the United States or Australia or the UK. It's a common law legal doctrine. And what it says is that sometimes a court may have jurisdiction over a dispute, and venue may be proper, so those threshold issues are met. However, there may be a more appropriate forum available to the parties. So when we talk about forum nonconvenience, what forum nonconvenience means is it's the right of a court to refuse to hear a case, to choose not to hear a case, even though it has jurisdiction and even though venue would be appropriate. A court may believe that there is a better suited location for this particular dispute. And the reason this comes up is that many people are concerned about a practice called forum shopping, which is to say a plaintiff will choose a court that will give to the plaintiff an advantage in the proceeding, a distinct procedural or substantive advantage. And so when we talk about forum nonconvenience, what we're really talking about is, well, what is fundamentally fair to both parties in the case? Now, a charge based on forum nonconvenience can be something that the defendant files. The defendant says, court, you should dismiss this case because it's not a good forum. Or it could be something that the court takes upon itself. Now, probably the most important forum nonconvenience case of the last 30 years was, or probably more than that, I guess, in 1984. In 1984, there was a leak at a Union Carbide factory in Bhopal, India. And it's probably one of the worst industrial accidents of all time, probably the worst industrial accident. Because what happened is a poisonous gas was allowed to leak out of this factory, and it killed, estimates range up to 8,000 people. And those that suffered injuries, there was probably another 8,000 who suffered injuries. And then there was all the pollution claims, generally the property claims that the poisonous gas hurt the property. So it was a terrible, horrible accident. And immediately after the accident, a wave of American trial lawyers, plaintiff lawyers, flew to India and signed up clients, and then they rushed back to the United States and filed lawsuits in the United States against Union Carbide. Now, Union Carbide was an American company, and therefore the court could exercise jurisdiction over this particular dispute and over this particular parties. However, what the court said is this court may not be the best place to hear this particular dispute, because all of the witnesses, all of the plaintiffs live in India. All the witnesses to the event live in India. All the evidence involved in the case is going to be located in India. Courts in India can exercise jurisdiction over the parties and over the subject matter of the dispute. So from a policy perspective, what the court said, it is better for policy reasons that this matter be heard in India and not in the United States. So this is a classic example of forum nonconvenience, in which a court that has jurisdiction and where venue is proper can still refuse to hear a case. The final thing that we need to know about in terms of forum selection are what we call forum selection clauses. And these are the clauses in which the parties agree in advance over what court will hear the dispute. The case on this issue, which is in your book, is called Bremen v. Zapata Offshore Company. And what this was, this case involved an agreement between an American company, offshore services company, and a German company. There was a contract to tow an oil rig from Louisiana to Italy. En route, there was a storm, it caused damage to the rig, and the towing company, Bremen, was forced to retreat to Florida, which is where the oil rig wound up, and which is where eventually the dispute was filed. Now, the German company filed a very similar dispute. It's a breach of contract claim. I paid you to bring my oil rig to Italy. You didn't do that, so breach of contract. From Bremen's perspective, they didn't get paid, even though they expected to get paid. So the question was, which court should hear this dispute? Should it be heard in London, which is where the forum selection clause said, and where the lawsuit had been filed, or should it be heard in the United States, where the oil rig was, and where one of the parties was, and where the evidence and the witnesses are? And so, should it not be heard in the United States? Well, the problem was there was this forum selection clause that says all disputes arising out of this agreement are to be heard in a court in London. And this is a case that went all the way to the Supreme Court. And again, the Supreme Court looked not just at the facts of this case, but they also focused on bigger, broader issues, which is to say, the future development of international commerce depends on certainty, and therefore, when companies put these forum selection clauses into their contract, they should be entitled to rely on the fact that a court will enforce that forum selection clause. So elimination of uncertainty is vital to commerce, and so given the potential harm to the plaintiff in this case versus the overall reasons, the overall policy reasons behind enforcing the forum selection clause, the court decided to enforce the clause. The rationale is that we want the applicable law to be predictable, and we must preserve the neutrality of the legal forum. That was the reason for choosing London as the place to hear the dispute originally, was for purposes of neutrality. Now, there are some exceptions to enforcing the forum selection clause. For your purposes on the test, if there's a forum selection clause, you can assume the court will enforce that forum selection clause regardless of other factors. However, you should know that if a party can prove that the forum selection clause is unreasonable or unjust, that the forum courts cannot be fair, then a court may be willing to disregard the forum selection clause. If there is a public policy exception, if the foreign court is going to enforce a clause that would be disfavored in the United States, for example, then the court may choose to disregard the forum selection clause. For instance, we have a rule in the United States that you cannot require another party in a contract to waive responsibility for any negligent acts. You can't simply say, you can't sue me for negligence because we've signed an agreement, and then I go be negligent and then you sue me. From policy reason, that's not effective. Therefore, if there was a situation like that, the court may not be willing to enforce the the forum selection clause. And finally, of course, the clause could be invalid for reasons of fraud. If you were induced to sign the clause without understanding what it meant, or if the party misrepresented what the forum selection clause meant, well, then you probably could resolve that agreement. You could, the court would be justified in not enforcing that agreement. But again, the general rule is forum selection clauses are enforced. I want you to know that, because what's going to happen is someday you're going to enter into a contract and you're going to have there's going to be a forum selection clause, and you must understand that that forum selection clause is going to apply.